Welcome to another episode of Litigator's Corner, and I'm here today with Will Marra, who is an investment manager at Validity Finance, who are headquartered in New York but do business throughout the country and different countries. Will, welcome. Thank you for coming today.
Thank you, Hillary, for having me today. I'm excited to sit down with you here virtually, and thanks for everyone for listening in.
Well, tell us about yourself and what you do.
Sure. So as you noted, I'm an investment manager at Validity Finance. We're a commercial litigation finance company, and I think we'll probably talk during this conversation about exactly what that means. The headline is we help people pay their lawyers. So either claimants or law firms who have good claims or are litigating good claims and need access to capital to bring those, we help support their litigation. We do commercial litigation funding. So that basically means business to business disputes, breach of contract, breach of fiduciary duty, intellectual property. And my role at Validity is I'm on the investment team. We're all lawyers on the investment team. And my role is to source the cases and to assist with the diligence as well.
And I think what a lot of people don't know is that there is a commercial aspect to litigation funding. I think a lot of people traditionally think of that as, well, I'm not a PI attorney, I'm not a med mal attorney. So what the services that Will and his company, as well as others, are offering are very important to a lot of lawyers these days, particularly people who are in, as I understand it, you also covered like things like copyright, trademark disputes, things like that, which people may not be aware of.
That's right. So there's one way to think about the litigation finance market is there's consumer litigation finance and there's commercial litigation finance. Consumer litigation finance, probably a little bit older in terms of how long it's been around in the United States. What you're funding there in the consumer market, things like medical malpractice, personal injury, mass torts. The commercial market looks a little bit different. Our Validity's CEO and founder, Ralph Sutton, is one of the pioneers of the commercial litigation finance market, and he started doing it in the United States in 2006. He was one of the first people to be doing it at the time, so it gives you a little bit of sense of the vintage. And what we do are business-to-business disputes. So in virtually every instance, the claimant we are funding is a corporate entity. It could be a corporation, could be an LLC. The biggest exception to that are sometimes we're involved in shareholder disputes where the claimants are an individual, but it's fundamentally a business dispute. And so you're exactly right in terms of the type of claims that we do. The full spectrum of IP, copyright, trademark, patent, there's trade secret misappropriation, contract, fiduciary duty. Validity, like a lot of other commercial funders, we invest in US, federal, and state court litigation and arbitrations. And we also do international arbitrations, both commercial and treaty arbitration. Funders typically do one or the other, right? They typically either do commercial funding or they do consumer funding. So as you're thinking about, well, do I need funding? You probably want to think about who's the right funder that I should be calling.
And well, I know that you are also a lawyer yourself, which a lot of people don't know. Can you tell us a bit about your background?
Sure. So I'm a lawyer by training. I previously, before joining Validity, was a litigator at a law firm in Washington, D.C., where the firm did a lot of plaintiff side contingency fee litigation, and I was involved in some of that. Before then, I did clerkships on the 11th Circuit Court of Appeals and at the U.S. Supreme Court. And what you tend to see in the litigation finance business is the investment team is usually comprised, if not entirely, primarily of lawyers, because fundamentally what we're doing is we're evaluating legal claims. And so having that legal skill set is very important to the job.
Tell us about your role at Validity Finance and the kind of services that a company like Validity Finance offers to law firms and claimants.
Sure. So as an investment manager, my role is to interface with both lawyers and claim holders who have the cases, to understand the cases, to be part of the diligence team that's evaluating the cases, And then in that group of cases that we end up funding, to help negotiate and bring over the finish line the investment agreement. So one way to maybe kind of orient people to that process is, what is the life cycle of a litigation finance opportunity? We get approached at Validity typically by either the claim holder, the person who has the legal claim, or the law firm that's litigating the case. Most of the time, there's already a lawyer involved, but sometimes the claimants will contact us before they even call a lawyer. Because as funders, we know lawyers throughout, all sorts of different industries. And so sometimes we're able to say, this is your type of claim in this type of jurisdiction. These are the 2 or 3 lawyers that you might want to contact. So at that point, the case comes in, we do some intake. First, you enter into a non-disclosure agreement. And then we start doing some diligence on the case, and we figure out if it meets our investment parameters. At which point, we offer a term sheet. Term sheet at Validity is a very simple 2-page document that lays out the basic terms of the investment. The amount of the investment, the return structure, and then typically you have an exclusivity period, usually of about 30 to 45 days, depending on the complexity of the case, in which we do our deep dive diligence. In parallel, we're negotiating the investment agreement. And then if we've agreed to terms and to fund the case, then we sign the agreement and the case is being litigated. Once we've funded, it's a very hands-off approach, right? We're not controlling the litigation. We're not controlling settlement. We're just advisors there in the background, but the lawyers and the claimants are completely in the driver's seat.
And how is a case funded? I'm assuming if, for example, I know that we had talked, and usually it's not worth it to you unless the case is being funded about $2 million or around there. That's sort of the benchmark. Is that correct?
So every funder has different investment parameters that they're looking for. So the same way that some funders would do commercial cases but not consumer cases, you'll also want to think about, as you approach a funder, how much of an investment do I need? So at Validity, for example, we're typically looking to do investments of about $2 million or greater, but other funders play in different portions of the market. So there are commercial litigation funders out there who will invest a few $100,000 in a case. So that's also, Hillary, as people think about who are the right funders to approach, part of what you want to think about is how much of an investment am I looking for, in addition to what type of case is it.
And when a case is funded, can you describe for our viewers how that works? For example, if you agree to fund a case for $2.5 million, a firm is not going to just get a check for $2.5 million that's going to sit in their trust account that can be drawn down on indefinitely. How does that funding work?
Great question. And this, I think, is probably a good point to talk about the different ways that funders invest in a case. There are 2 main types of investment structures, you could say. There are other things that litigation funders do, and we can talk about that, things like claim monetization, appeals funding. But the 2 most common things that we do at Validity and that our peer funders do are single case investments and portfolio investments. And I think that's an important way for lawyers and claim holders to think about what kind of funding they need. So a single case investment is an agreement, as it says, for one case, an agreement between Validity and the claim holder, not the law firm. The agreement is between Validity and the claim holder, essentially to pay a portion of the fees and costs of a case on the claim holder's behalf. So what does a typical deal look like? So to your question about, okay, what if we're funding $2.5 million? Exactly, brass tacks, what does that look like? At Validity, like a lot of other funders, we think about the investment needs of a case as falling into 2 and then sometimes a 3rd category. First, legal fees. right? Everything that is going to the law firm in attorney hours to litigate the case. Second, expenses, and that's everything from expert fees to court filing fees to hotel fees, stays during your depositions and trial. Sometimes there's working capital, which is cash directly paid to the company for its operating expenses. But the fees and costs are really the most basic form. And so when we think about litigation finance, a lot of us just immediately think fees and costs funding. And so what does that look like? Usually on the fee side, we're paying something like 50% of the fee budget for the case. So if there's a $2 million fee budget, we'll pay $1 million, and the law firm will invest another $1 million of its time. And then for the cost budget, we'll usually pay 10 to 90%, depending on the claimant's ability to pay. So let's say this cost budget has $1.5 million of costs, and we're going to pay $1 million. So in that example, you have a $2 million commitment by Validity, $1 million in fees, and $1 million in costs. Now, to your point, we invest that money as incurred, right? So we don't just cut the check to the law firm on day one. As the law firm bills its hours, we then pay, say, 50% of those hours as incurred. Well, why would the law firm discount its fees for 50%? The reason is it's getting a contingent upside. So what it essentially looks like from the law firm's point of view is a partial contingency, right? Where they're getting maybe 50% of their fees paid by the funder instead of the client, or you could say that by the client, the funder's doing it on their behalf. But they also get maybe 20% of the case proceeds in the event of success. So that single case portfolio looks a little bit different, and we can talk about that as well.
And that was my question. How does a law firm get paid? How does a client get paid? And how do you get paid at the end of the case? Could you sort of describe that for everyone, how that would look, and just for an example so people can understand how that's going to look?
Yeah, definitely. And the first starting point I think that folks should have in their mind is what happens if the case loses? The hallmark of virtually all litigation finance transactions is that it's non-recourse. And what that means is if the case does not succeed, the funder gets nothing, right? So that's a big difference between, say, taking out a loan on your home or on your business to finance litigation, where if you don't win that litigation, the bank is still going to ask for the other collateral. For litigation finance investments, the only collateral you could say are the cases themselves. So if the cases don't succeed, the funder gets nothing. The law firm keeps whatever percentage of its fees Validity has been paying along the way. And the claimant, of course, there's no recovery for the claimant. If the case succeeds, then you look to the return structure. Really important for us at Validity that the claimant should be getting in those success scenarios 50% at least, and more likely 60% or more of case proceeds. We think that's important for the transaction to be fair to everyone involved, with the remainder being divided among the law firm, their contingent upside. So they would be getting 50% of their fees paid along the way, plus whatever percentage of case proceeds, and Validity would be getting its return according to the parties' agreement.
Why is litigation funding another option for lawyers? I know that your colleague Peter Pettit and I conferred yesterday on Litigator's Corner. I think a lot of people don't realize this is a very important tool to have in a law firm's arsenal. Can you tell us why?
Yeah, I think that's right. And is litigation finance the right answer for every solution? No, of course not. Sometimes it's going to be appropriate. For example, the claimant just wants to pay by the hour. But I think you put it right, where it's one of many tools, right? And if you have a toolbox, sometimes you need the wrench, sometimes you need the hammer, sometimes you need whatever, right? And I think it's important for lawyers just to be aware of litigation finance as a tool. And if you kind of put it maybe in a little bit of historical context, and probably a lot of lawyers listening in might say, I recognize a situation like that, right? Historically, really two ways to bring a case on the plaintiff's side. You could pay your lawyer by the hour, or your lawyer could do the case on a full contingency. Well, what are the problems here, right? Not everyone has the money to pay their lawyers by the hour, hundreds of thousands of dollars or millions of dollars to bring a case. Sometimes they have the money, but they don't want to risk it on the case, right? Because they'd rather focus on making their widgets, which is their core competency. So sometimes people can't or don't want to pay by the hour. And then on the law firm side, as lawyers will know, not every lawyer has the ability or the risk appetite to take a case on a full contingency. And so what happens is sometimes lawyers get called in these situations. Hey, I have a great case. I want you to take it, but I can't pay you. And the lawyer sometimes has to turn away that business. And so litigation finance is a way to sort of meet the risk profiles and the liquidity profiles of the law firm and the claimant and allow them to work together, right? So that the claimant can bring the case with the litigation strategy that they need rather than the litigation strategy they can afford. So sometimes these cases might get brought anyway, but they just wouldn't get brought with the same quality of counsel, the same quality of litigation strategy that you might not have without litigation finance.
And I think that's very true, Will, which is why I'm so glad that you were here today to tell us about this. Because I think most lawyers have been approached with, he's like, yeah, I'd love to take this case. It looks like we could win this. It looks like there's a good upside, but the time and the money you're going to take into this to try this case, I'm sorry, we can't do it. And, the law firm, it's a loss for the firm, because it's something they would want to take. And lawyers, we can't always get what we want, but, we like to think we can. And for the clients too, they may get lesser representation or have lesser options, or go with an attorney that they maybe really don't want to have as their attorney because it's what they can afford. And that's the reality, I think, of most situations. But I think there's that access to justice too, or the legal system, that you're also helping people. I mean, again, you're higher dollar cases, not all companies do, but I think there is that aspect to it. And I know, Will, that we'd also talked about the fact that maybe a person does have the money to pay their legal fees, but wants to use that money for something else. They want to remain liquid. They want to develop their business, or maybe it's like anything else. I could pay off my mortgage, but I'd rather keep the cash, so something like that. And I think could you tell us a bit about, having that option really does give more options to a client too?
I think that's exactly right. And Hillary, you're speaking my language in terms of bringing in these analogies to other areas of life where we're just a lot more familiar, right? So let's say someone owns 3 restaurants, right? They might have the money to pay for some litigation that they're involved in, but they'd rather build that 4th restaurant or keep paying their employees or hire new employees, right? So the same way that people take on equity and debt financing in every other area of our commercial world, right? Everything from private placements and friends and family to the New York Stock Exchange, right? All of that are folks sharing the risks and rewards of an endeavor. And the insight is basically the same. And to your access to justice point, that's one of the most rewarding aspects of this job, because we really do see it every day, right? We see companies that are put out of business, right, because of a breach of contract or a trade secret misappropriation. And they just don't have the funds anymore, right, to bring that litigation, or to bring the litigation with their first choice counsel. And so you see there in some of the things we've been talking about, 2 very different profiles of claimants. You have the liquidity constraint, those who just don't have the money. We often think about that as David versus Goliath. But then you also have the risk constraint, right? The restaurant business that's doing pretty well and has some money in the bank, but doesn't want to risk it all in the case because they'd rather focus on their core business.
And Will, I know that we've talked about it a bit, and I have seen these cases where someone is legitimately wronged, but they're not liquid enough to try it. Or they look at what the bill is going to be for their lawyers and how many years it could take to get a result, and it's just not doable for them, or they don't want to put all their eggs in one basket. Well, I know that we've conferred a bit about this. I know that you're not involved on the day-to-day once the case is funded, But have you seen cases where having litigation funding has actually spearheaded a settlement? For example, my firm does a lot of employer defense. And I know it is always a defense when you're working with the plaintiff's case to say, yeah, you're probably taking this on contingency. I'm not, there are rules of ethics. And again, I'm licensed in California, New York, and other states. So there are rules that we have to abide by, and we do have to be professional. But it's always a defense to say, I'm not going to hustle along with this because I know you're not getting. Does this change that dynamic, having this litigation funding? Have you seen it happen? Have you heard about it happening?
It's a great question, and there's a whole interesting debate in some of the academic scholarship about this very question as well. It's always hard to know kind of exactly what's happening in any one case, but I think I think one thing that we can say is if you really need the money to operate your business, I think defendants historically in situations where they're going up against cash-strapped plaintiffs, right? Page 1 of the defense playbook is usually drown them in stuff that's going to drag this out forever and force them to settle because they need the money today and they can't keep paying their lawyers. And so I think part of what litigation finance is trying to do is really level that playing field that in a lot of these disputes is pretty heavily tilted towards the defense side, particularly where you do have this David versus Goliath setup where the defendant has, for relevant purposes, unlimited funds, and the plaintiff without funding has very finite funds to pursue the litigation.
And in this day and age, insurance money, there are a lot of policies now, even with the pandemic, that allow for defensive harassment claims, shareholder dispute, lots of different kinds of, they have negligence E&O with directors, they have a lot of these coverages, copyright infringement, a few $1 million. If you have that much coverage and you're looking at this and the law firm goes, great, the insurer has a duty to defend, I'm getting my fees paid, why don't you go ahead? Most plaintiffs, particularly in these situations, aren't going to be able to afford that. Well, I know we have a few more questions, but I know that you are having an article published in the Vanderbilt Law Review that is called The Shadows of Litigation Finance. So can you tell us about without spoiling the surprise, can you tell us about the arguments there that you have?
Sure, and it actually kind of picks up, I think, on what we were just talking about, Hillary, and what we tried. I co-wrote it with a professor at Indiana University, and what we were trying to do in that article is say, let's step back a little bit and talk about what are the effects that litigation finance has on parties' behavior. First, we thought it was important to write the article because there are a lot of conversations being had among lawyers, among bar associations, regulators, academics about litigation finance. And we thought that the conversation wasn't talking enough about at least one important effect of litigation finance, which is a lot of the conversation is around what are the effects that litigation finance has once funding comes into a case. So questions like you've been asking, right? Once funding comes into a case, are cases more likely to get filed? What are settlements going to look like? Are settlements and jury resolutions and bench trial resolutions, are those going to change? And we talk about those, but we say there's also an important effect that a lot of people haven't been talking about as much, which is the effect that litigation finance will have on parties' behaviors even before a dispute happens or before the parties are in litigation. And one of our arguments is that when parties know that if they breach a contract, the other side will be able to better enforce their rights through use of litigation finance, you're actually going to have fewer contract breaches and fewer unethical behavior, essentially, but from the stronger party to the contract, right? So a lot of these David versus Goliath scenarios, we see them a lot. One of the best explanations for what's going on is that people figure, look, I can do this because you're not going to be able to go after me. you're not going to have the ability to enforce your rights. And the argument that we make that I think, is right as a theoretical matter, and I think I've seen as being correct in my job, is that it's actually going to affect parties' behaviors in a really positive way, in terms of people are going to breach their contracts less frequently. And also, as a result, they're going to be more likely to enter into contracts. So you could actually have this spur to commercial activity because you're more comfortable entering into an agreement with a wider range of parties, knowing that you can better enforce your rights against them.
So on the one hand, you have the deterrent effect where people go, they're never going to be able to do it. They're never going to be able to do anything about this anyway. So I've got them here, and now they don't. And then you have, on the other hand, people are going to feel more comfortable because anytime you sign a contract, you're like, well, what if this goes south?
Precisely.
They're telling me what I want to hear now because they want me to sign on the dotted line. But after I sign, I've given up control. And what does that mean if there are problems? I can't afford, this. That's what the claimant is going to say. I can't afford to pay this. I can't afford to sue these people. And who's going to take my case? And that's a mess. But if they know they may have funds available to do that, it makes them feel a lot better. Oh, I have insurance for this? Great. That's the same kind of feeling, that feeling of security.
Precisely. And so it's exactly right. And so we say there are these pre-claim effects and post-claim effects, right? The post-claim effects, after the claim cause of action accrues, someone has a cause of action. The conversation has been happening around that, but folks have been overlooking some of these important pre-claim effects. And so to the extent we're going to be coming up with policy judgments and potential regulations or whatnot around litigation finance, we need to make sure that we're considering all of the welfare effects.
Yeah, and getting into regulations, when I first saw that there was litigation funding a few years ago, I looked and I thought, you can do this. And then I thought, is this ethical? Can we do this? Tell us about that.
Yeah, so it is perfectly ethical. It is as you might guess by the fact that there are so many litigation finance companies, so many of the very best law firms in the country using litigation finance. One of the issues that is probably coming up, so at first some folks were saying, hey, maybe this is illegal, typically under state champerty laws, and for the most part, certainly at least in the major commercial jurisdictions, that's just not a barrier to the types of commercial litigation finance transactions that Validity and our peer companies do. The issue where the conversation has more shifted towards is a question of disclosure. So if you are a plaintiff and you have a litigation finance agreement, do you have to disclose that to the other side? There's two ways in which this question usually comes up. First, should there be a mandatory rule requiring disclosure in all cases? And for the most part, there are very few jurisdictions that require mandatory disclosure of funding. The New York University Law School just published, Center on Civil Justice just published a collection of essays, and I had an essay in there on mandatory disclosure and talking through some of the policy reasons for and against. So that's typically not really an issue. Then you have case-by-case disclosure. So some defendants during a case say, hey, in their, say, interrogatories, they say, or document requests, they say, tell us about your communications with funders and hand over any funding documents. The trend among the cases is these documents are not disclosed to the other side. Courts typically so rule for one of three reasons, each of which is sufficient. Either first, the documents are not relevant. Second, even if they're relevant, they're protected by the work product doctrine. Or third, they're protected by the attorney-client privilege. It's always wise, nevertheless, as a practice tip, to enter into a non-disclosure agreement when you first speak with the funder to maximize the protections that you'll have.
And Will, are you seeing courts make any rulings about privacy? Because it does pertain to finances. So we often see that. When a shareholder derivative suit, it may be different. And the financial privacy probably has a different meaning. But often it's, third-party rights of any kind of financial documentation as to how the fees are being paid, as long as they're not looting the company, is often off limits. Are you?
Yeah, so it's a really great question, and I'm trying to think and can't immediately think of cases that explicitly use that language, but I think what you're getting at is a big reason why the strong trend among courts is to deny discovery, because it does create this asymmetry, right? First of all, defendants don't have to disclose, where they're getting their funds to pay their lawyers. And then on the plaintiff side, and this is what my essay in that collection that I just referenced is about, you don't have to, for example, disclose if your lawyer's on a contingency, certainly not mandatory rule to do so at the outset of litigation. So why are we kind of picking on this one particular type of funding by someone other than the litigant when we don't mandatorily disclose if a family member is paying your legal fees or a pro bono organization is paying your fees? And I think that that fact plays in. I think the other point that I think is working in a lot of these cases is, do we want to put litigants to the choice of either A, not bringing their case because they can't afford to do so, or B, bringing their case at the cost of having to reveal all of this information? And that's a really uncomfortable and frankly, I would argue, unjust position to put people in. And I think judges realize that and don't want to have to stick litigants with that bargain or with that choice.
Well, I know that you're with a reputable, well-established business, commercial lender, but not all of them are. And what are some of the things that you should look for when you're choosing a commercial lender? I know that we've discussed some unfortunate situations, for example, where people will go through the funding assessment process only to find that there's no money there, that they're never going to receive a check from the lender. So they've been put behind, so to speak, in terms of time and effort and getting your hopes up. And what do you look for in terms of a reputable lender? Because I know that there's been a lot of growth in your industry, and which is great because you have a lot of reputable, strong companies like yours involved, but you also have a lot of, well, frankly, for lack of a better word, yahoos who are jumping in on these things that want to get a piece of the action, and maybe they're not behaving appropriately.
Yeah. So the good thing is that the commercial market, which is what I'm most familiar with, I think is our peer companies are all highly ethical and I think are all committed to doing this business in the right, proper, just way. That's especially important at Validity. I think there's probably a few questions that folks can ask when they're looking at a funder. First is, do you have experience in this industry, right? Our CEO's been doing this for 15 years. Our team has an average of, I think it's something like 5 or 6 years of experience in litigation funding. So that's one question to ask. How experienced is your team? Another question to ask is, where's your capital coming from? So we're happy to tell people the source of our capital. Our primary investor is a private equity company. Do you have committed capital like Validity does? Some other people might be a broker, right? They might not have the capital already committed the way that Validity does, and then that's maybe sometimes where you have some of these examples that you alluded to, where someone enters into a deal and they actually can't come up with the money to fund the case. So I think, kind of looking at the experience, looking at the commitment of capital. And then the third thing is, what are your values, right? Why are you doing this? And at Validity, that's, points number 1, 2, 3 to 10 that we really emphasize, which is we're committed to doing this business in a fair, clear way that puts clients first. And I think that's really important for the growth and future of our industry.
And that's one of the nicer aspects of Validity and some of the other companies where they're making the client a priority and giving personalized attention to cases. Because I know that you are flooded with calls all the time, and the percentage of cases that you take are actually quite low, comparatively speaking, to the number of calls you make. So you do have a high standard there and a good screening process.
Yeah, and for most commercial funders, probably they're investing in less than 10% and sometimes less than 5% of the opportunities that they see. That said, every time we get a call, that case is one of, if not the most important thing going on in that person's life. And it's really important for us to remember that, no less than it is for you or any lawyer to remember that when they're dealing with their client. And that's really the approach that we bring to this. And we're all lawyers who sat in that seat previously. So we know what that's like and the importance of that.
When your company does its due diligence, what does your due diligence look like, and what do you want to see from lawyers? What can we do our part to help in this due diligence process?
Yeah, great question. How do you get your case funded? At the highest level, we are going to look at a case pretty similar to the way a law firm is going to look at a case when it's thinking about doing it on contingent fee, right? And so what does that involve? Anyone who's thought about doing a case on contingent fee can answer that question, right? It's what are the merits of the case? Are we gonna win? Do we think we're much more likely than not to win? But there's also other questions as well, right? What are the damages such that the investment of time and money will be worth it at the end? If you win, can you collect against the defendant? So collectability concerns, if there's going to be an important collectability issue, important to highlight that. And then how long is it going to take, right? Is this a case that we think is going to resolve in 2 years, in 5 years, in longer than that? The very best funding requests that we get, they have a memo that goes through these various issues. At least if the case is pre-filing. If the case has already been filed, then we'll want to look at the complaint, dismiss, summary judgment, so on. But otherwise, I think that the one piece of advice that I would give people who are looking to get their case funded is really think hard about the most challenging issues for you to take the case at least on partial contingency, and do your best to tee up those issues, right? We don't want, as one of my colleagues like said, we don't want a motion for litigation funding, right? We want to not just your very best foot forward. We want to understand the case. We understand that no case is perfect, right? Every case has its strengths. Every case has its weaknesses. We just want to try to understand those strengths and weaknesses, and obviously to the extent that we can add value to the case as well.
Well, I know that we had talked about there's a lot of growth in the commercial litigation funding industry. Where do you see this going, and what kind of growth do you think is reasonable to expect? I mean, no one knows for sure, but what are your thoughts on that?
Yeah, so it's a really good question, and certainly over the past couple of years, we've seen a lot of new funders enter the space. That said, I have a lot of conversations with lawyers who are learning about funding for the first time, or even if they know about funding, have never entered into a litigation finance transaction yet. So I think on the lawyer side, we have increased familiarity. And just because you know what litigation finance is doesn't necessarily mean that you know enough about it to enter into a transaction. So I think the market for funding, in terms of just which lawyers will be able to use funding or will want to use funding, is growing significantly and will continue to grow. And then I think on the claimant side, you have more and more sophistication about using funding. And frankly, you have a lot of instances where companies that historically have been paying by the hour are now aware of funding and saying, wait a second, maybe in the past I was paying by the hour, but I have much better uses for my capital today, right? To build my widgets rather than pay my lawyers. And so I think the demand on the client claim holder side is increasing as well.
So this just isn't a benefit for law firms. This is a benefit for claimants as well, because it's giving them more options. Well,
precisely.
This has been so helpful and so informative, and I appreciate you making the time, particularly from the East Coast, to do this, as well as the very helpful MCLE that you presented earlier a couple months back. So thank you so much, and we appreciate you coming here today for Litigator's Corner.
Thank you, Hillary, for hosting. It's been a pleasure, and I enjoyed this conversation.